Welcome to the second episode of the Lobby Bar podcast. We're still experimenting with different formats, and today we're going to be doing cocktails and cases, where we talk about cases, have a drink, and just discuss what's going on in workers' comp. So today it's just me and Jason Ginhart. Say hi.
Hey there, Roy. Hey there, everybody.
Hey. How's everything going, buddy?
Good. Yeah.
So I know Jason has a few cases he wants to discuss. I have a few that I'm going to be talking to everybody about. The first case I wanted to talk about was Garcia versus Mendoza, doing business as Sweet Melody Express. So this is a case where the defendant is a custom dressmaker. She works out of her home, has no employees, because she's the only one that makes the dresses. And the applicant happens to be her housekeeper. So the housekeeper comes, periodically, cleans the home. And the facts would suggest that on occasion, the applicant did do some work on the dressmaking side. The applicant was injured in 2014 in a specific incident, and she tried to claim workers' comp against the defendant. The defendant obviously fought it, and the case ended up going to trial. The issue at trial was the applicant an employee of the defendant, either as an individual or as the business? And so we all know that there are residential employees, people that come into your home and do work and things of that nature. And so they went to trial on that issue. And the real bottom line issue was whether the applicant was actually an employee or whether the exemption that would exclude the applicant pursuant to 3352.8a applied. And that particular provision requires that for a residential employee to be considered an employee, the applicant had to have worked for the defendant more than 52 hours in the past 90 days. And the applicant didn't prove that bar. And so in this particular case, the real takeaway was that the burden of proof lies on the applicant to prove that they are an employee and that the injury happened in the course of their employment. If they don't meet that burden, then they can't prevail. And so in this particular case, the applicant didn't do enough to prove that she was an employee, didn't prove that she worked more than 52 hours and didn't fit within that exemption. So that was, appealed, and the WCAB on reconsideration upheld the decision and said, essentially that the applicant didn't prove her burden.
Yeah. So I think, Roy, when I was reading this case too, I had a few things that stood out to me. And I guess to start off for everybody on these cases, the cases that we're both talking about, other than the new case that just came out, the applied materials case that we'll talk about at the end, all of these cases are panel cases, so they're not necessarily binding. They're persuasive and but certainly citable in comp. But when I saw this case about the burden of proof, when Roy and I are dealing with new attorneys, a lot of times, and dealing with applicant attorneys and clients, it gets lost in the mix on whose burden of proof is what on different issues. When you're
Absolutely.
litigating, and as far as AOE, COE, employment, that's the applicant's burden. If that goes to trial, it's always important as defendants to know that they have to establish that. But then on the flip side, things like affirmative defenses and and apportionment, those kind of things are entirely our burden to prove at trial, and then the burden flips. So I think it's important to remember that, yeah, when you have a case like this, and you are going to trial, that and this case affirms it, that things like AOE, COE are entirely the applicant's burden to prove, and in this case, they didn't. She didn't do it.
Right. And to be honest, like I was looking at that 52 hours and, like other than like nannies and people that are like full-time employees or, like pretty serious hours in somebody's household, it'd be pretty hard. Like you would have to be a pretty filthy motherfucker to have someone clean your house for 52 hours in
Oh
90,
yeah.
90 days.
Well, in those kind of cases, it's a lot of times it's, these landscapers that are trying to bring it, that get hurt on properties, and contractors and stuff like that. And then, yeah, you're right. I mean, it's a lot of hours
Yeah,
to establish.
it
So
is.
yeah, especially like you said, unless you have a live-in nanny, which I
Yeah.
guess outside of our realm.
Or you just have a huge house, where
Yeah.
someone has to clean it for 5 hours every week. But
Yeah.
yeah.
So the case I wanted to, the first case I was going to talk about was also a panel case. This is the Avila versus Sutter of Santa Cruz case, and it's a case about the 6-month rule for psych under 3208.3D. So, as has long been established with psych and the 6-month rule, the 6-month rule doesn't have to be continuous. That's right in the labor code. So there's a lot of cases on that, and specifically the Gottschalk's case. But this case was a little different because this person, this is actually a really old case that must have been being litigated for 18 years or so, because the date of injury is 2002. So this lady worked as a receptionist for about a month in 2002. But prior to that, she had worked for the same employer for a year and a half, left the employer, worked for a year somewhere else, comes back, works for a month, files a claim, physical injuries, along with psych. So it's a large case. It's an 89% PD case. They have a psych AME as well as an orthopedic AME. We're talking 89% PD. So it was a heavily litigated case, obviously, for a long time. Goes to trial, and they're litigating whether or not psych is precluded under the 6-month rule. The judge finds that it is not, that even though she only worked there for a month, she had previously worked there for a year and a half. So the 6 month of employment was essentially met. It gets appealed, goes up on recon. The commissioners review it, and they find for the applicant. And they basically indicate that the labor code says it doesn't have to be continuous. And because she did work there, even though there was a break of employment essentially, and even though she's accepted a new job and went somewhere else, that the labor code was satisfied. So the defendant made a good argument, and I still think it's a good argument, that the second period of employment was clearly not an extension of the first period of employment. She left, she gets another job, and then comes back, so that it should be considered a new period of employment, thus restarting the clock. But the commissioners in this case didn't agree with that, and found that
Did they give any guidance as to like how long that break could be? I mean, are we going to say, okay, a guy goes away for 5 years and then comes back? Like
they didn't. So
didn't.
they said in the case was that labor code says it doesn't need to be continuous, so we are not going to make the labor code any more restricted than it says in its face. So it says that you have
Because
to be
I've
6
seen
months.
this in practice prior to this case, but it was usually seasonal workers, so somebody that works, like 3 months and then is off for the off season, then works another 3 months. And then it ends up being a total of 6 months in the past year. But, like it was like seasonal. And so
Yeah.
I could
Well, I
see
think that was
why
the
they would.
intent of the. Oh, go ahead.
Yeah, I mean, I could see why that would be considered within the intent of the labor code, but I don't see how someone just leaving and getting another
Yeah.
job and then deciding to come back, how that is like somehow a continuation of the work stress. You know
Yeah.
what I mean? They were interim events, but that's a
Yeah. So so the commissioners in their decision said, well, there's no requirement that it be a continuation or an extension from the first period of
mm,
employment to be considered in the time frame. It's not. It is a panel case, so it's not binding. And then, I could see that if you had a case that was a little different, if I worked at McDonald's when I was 16, worked there for a year, I'm 40, I go back and work there. Day two, I file a site claim. That set of facts, I
right,
think, would be, when I've had 10 different jobs in the interim.
right.
I can't even remember that I worked there. That I think it's might be a little fact specific, and I could
Yeah,
see the judges taking but it's the same rule. So I don't know,
it
but
just seems fuzzy, right?
oh, it's fuzzy. Yeah.
Yeah,
And it doesn't
because
make a lot of sense to me. It doesn't make
no,
sense
because
that you leave
why does the 6 month rule exist? I mean, if they're saying it doesn't have to be a continuation of the prior employment, like the whole intent behind someone having to work there for 6 months was because like we didn't want to just give people like the right to come in and work for 2 weeks and say, oh man, this is too stressful.
Yeah.
um, I gotta file a claim, like someone had to put in some time, you
Yep.
know but
Yeah, it was to avoid fraudulent claims and these things coming up, like you
right.
said, on the second day of employment, which, so yeah, it's a fuzzy case. I think it's back specific. If I had a case come in and I was litigating it and it was at all different than this, or if it was a longer period of time, or maybe even if it was the same similar set of facts, I might give it a go. And
Yeah,
this I
I
think would
think
be
I
a
would
good
still
case.
fight it.
Oh yeah,
Yeah.
and this would be a good case if I was on it, where I would be looking at filing a writ. When you're
Oh
talking
yeah.
about an 89% PD case and
Oh heck
psych is
yeah.
the main big portion,
Yeah.
there's no way I would take that line down
No.
on a recon.
Yeah.
There's too much at
Yeah.
stake, and
Because
and it does it's nonsensical, in my opinion.
yeah, and like I said, like it's just too fuzzy for it to be law.
Yeah,
Like there's got to be some there's got to be some guideline to say, okay, this is what the labor code's intent was, and so we are going to make the judgment call to say that this is the amount of time. Like if they don't do that and they just say, well, it doesn't have to be continuous, there you go, then I just don't see how that just flies.
oh yeah, agreed. Yeah.
All right. So the next case I wanted to talk about was Lee versus Kaiser Permanente. And so this is a case that handles some issues that are probably one of our favorite topics, which is liens. And so this is really a tale as old as time. A case where the defendant sets the depot, notices the depot, advises all the parties that we're going to, schedule a court reporter and an interpreter. We show up to the depot, and the applicant's attorney walks in with an interpreter of his own because he doesn't trust our interpreter to, I don't know what, right? Like, what would our interpreter do that would jeopardize their case? But they often do this. And then we end up getting a bill from their interpreter and obviously our interpreter um, for the deposition. In this particular case, the defendant fought the lien for the applicant's attorney's interpreter, and kudos to them. But essentially, what the court found was that because the defendant noticed the depot, they were responsible for providing the interpreter. And so they had to do it. That's part of our responsibility. If we were to schedule a depot and notice it and not provide an interpreter, we'd get in trouble for that. However, because we were the party responsible for it, um, our interpreter was the one that should have been handling it. And so they gave some guidance on how an applicant's attorney could get their own interpreter to do the prep, in objecting to our interpreter for the prep when we noticed the depot and advising that they would be providing their own interpreter, so we could book an interpreter for depot only and not for prep. But short of that, they're basically saying, if they just show up with an interpreter without any pre-discussions of what should be going on at the deposition, the burden is on the lien claimant to prove that their charges were reasonable and necessary. And if they can't prove that by showing that the applicant did object on time and did advise that they would be providing an interpreter for the prep, they're going to have a hard time proving that their lien was reasonable and necessary. And so I think this is a great case for us. And I think our defendants should be taking a close look at the lien situation when it comes to interpreters and making sure we object to the lien if the applicant's attorney shows up with their interpreter.
Yeah, and I think even aside from when you say that they're bringing their own interpreters because they may not trust ours, I think that could be the case sometimes. But I think a lot of times in practice, these applicant attorneys have close relationships with one interpreter. And
right.
You notice that even at the board, of course, when he used to go, or in depositions, they are always dragging the same interpreter there, and so right. I don't know what the arrangement is, but I think it's just they're just trying to give work to their interpreter, and they know that when you're talking about a $200-300 bill, that defendants typically don't fight those, especially when you're talking about the grand scheme of things. So like you said, kudos to this defendant for actually, taking it up on a recon. Going to a lien, they go to a lien conference, they're fighting a $300 bill. Then they take it to trial, they lose, and they go on, and they take it up to recon. So, they spent 5 times at least the amount of cost fighting it.
Yeah.
But they established some precedent at least. And know that
absolutely.
With at least that applicant attorney, they're not going to be dealing with that.
And you really have to credit Kaiser and their team because at the end of the day, not a lot of employers would be willing to spend that coin to do that, but they really took one for the team on this one.
Absolutely. So my second case, so I had 3. My second case here is Tull versus Department of Corrections, which is a very new case, panel case. I think it's another good case for defendants relating to asserting credits, and specifically asserting credits in multiple cases. So it's a rather complicated case, but the basics of it are: it's a 2001 admitted case, stepped out. Applicant files a petition for new and further, as well as filing about three other subsequent claims. They go back to the AME, Dr. Avila, in 2009, and Dr. Avila says, well, yes, there's some new and further disability for one of the body parts, and in good faith, the defendant go ahead and issues a check for about $22,900 in permanent disability, the additional permanent disability that would be due for the additional PD based on that report. Well, apparently the case doesn't get resolved right away, probably because of the additional 3 cases that were filed. They go back to the AME down the road in 2015 and 2016. And in these subsequent cases, or subsequent reports from the AME, he says, well, it's not new and further disability from the 2001 case. This is actually PD on the new CTs. So the defendants there, they've issued all the PD, but they've issued it on the old case, and they assert credit on the new CTs, which seems logical. So obviously the applicant attorney doesn't agree, wants duplicate PD payments issued on the new cases, doesn't want the credit asserted, and they go to trial. It goes up, and the board finds that no, in this case, based on Labor Code 4909, the WCAB does have the power to award credit even across multiple cases. And they specifically said, so the board, in this case, they use basically an equity test based on prior cases to determine if they're going to allow credit. And in this case, they said allowing the credit would not cause significant disruption in the applicant's benefit and would not be inequitable. So they allowed the credit against the other cases, which is important because there's a prior case, the Donahue case, which also related to multiple dates of injury, where the WCAB said that defendants could not assert credit. That was a slightly different fact pattern, where a defendant had a specific and a CT that were overlapping, and the defendant got apportionment between the two, paid all the PD on one, and then wanted credit against the other. And in that case, the WCAB said that they couldn't assert the credit because the defendant should not be able to benefit from the apportionment of the PD, and then also the consolidation of the cases on the PDA issue, which made a little bit of sense, but still the applicant is getting double benefits in that sense. So they distinguish it from the Donahue case. But all these credit issues, as we know when we're litigating them, are very fact specific, because it is an equity test. It's, did the defendant act in good faith in issuing the benefits? Did they delay the benefits? Did they issue them on time? Those things are all factors. And in this case, they immediately issued good benefits in good faith, and they were allowed to, or awarded the credit against the cases. So I think the takeaway on it for me is that, from a defense standpoint, if you do the right thing, and your client issues payment, and it's later discovered that, okay, yeah, the payment should have been issued on another case, I think this is going to be a good case where you can say, yeah, it should be allowed, because it's not prejudicing the applicant in any way by doing it.
Right. Yeah, this one I felt like it felt like common sense, but in workers' comp, even things that feel like common sense always are like pulling teeth.
Yeah, and even the common sense stuff sometimes doesn't work out.
Doesn't go our way, yeah.
Well, when you have to fight to get credit for payments that you've issued in good faith, just because it should be under a different claim number, that's where.
Yeah, they're trying to argue. Like, applicants' attorneys always do this, though. They try to argue syntax, and it's like, hey, man, like, we're just trying to deliver benefits, right? And you're saying we paid it on the wrong claim, so we can only assert that credit against what? Future treatment on just that claim? Come on,
Well, and the whole point of allowing credit under the labor code is to encourage defendants to issue benefits to applicant without delay, because otherwise, if you had any doubt, because
we'd be arguing it.
Yeah, the defendant in this case could have said, well, there's 4 cases here. I want to make, if there was no credit possibilities, you're going to say, well, I'm going to make dang sure that out of these 4 cases with overlapping body parts, there's no apportionment across these cases. Right. There's no new CT before I'm going to issue $1. Right. And then the applicant's sitting there waiting. Right. So, there'd be a lot of unintended consequences if these judges took a hard stance on these credit issues, especially when the defendant's just doing the best they can, essentially, which is in this case, they did the best they could.
Right. In law school, they called that a chilling effect, right?
There you go, Ro. I see. I remember very little of
me too.
Law school. And I had one more panel case before we jump into the new case that just hit the wire a couple days ago. So I also wanted to talk about the Rosenbrook versus Knight Swift transportation case, which is about kind of the new telehealth QME situation that we've all been dealing with. And I'll make this really brief because it's a fact specific situation too, and it's dealing with these new emergency regs that we're all dealing with. So we know there's the current emergency QME regulations, which were extended, and they're still in effect. They're in effect till at least October 2021. And the emergency regulations give about 4 points on when a telehealth QME evaluation would be appropriate. And in this case, the defendant was doing everything they could to fight and not allow a telehealth QME appointment to go forward. The QME in this case said it would be appropriate, that he could do it. that he didn't need it to be in person. The applicant didn't need to travel to do the telehealth, sort of hit all the points that needed to be done. The defendant still didn't want to allow it. It goes up, and in this case, the WCAB says, well, no, the defendant cannot unreasonably deny a virtual QME appointment. So I think the takeaway for me on it was not that you have to allow every virtual QME appointment, because there are certainly situations where measurements need to be taken that cannot be done virtually. But this, I believe, was a reevaluation of an internal, so it's probably more of just an interview because the doctor said he didn't need to physically see him. So my takeaway was, you fight the ones you need to fight, but if it's simply because you don't want to do it, you probably should let it go forward, because at some point you're just delaying the inevitable, and you got to get the evaluation done. The defendant in this case was essentially arguing that they wanted to wait it out and have him evaluated once all COVID restrictions were lifted, which is, I would have thought they would have been lifted 10 months ago. So I would have, I'd still be waiting if I was doing this last year.
Yeah.
So,
I feel like it's tough to put that responsibility and trust into the doctors, because if you're going to if you ask me, and I'm a doctor and I haven't seen patients for how long, and I have a boat payment and vacation home payment to make, and someone asks me hey, can you see this person via telehealth? I think 10 times out of 10, I'm saying, hell yeah, I can do that. Yeah. Regardless of whether measurements need to be taken or not. And so it's what I didn't like about this case is they put that all on the doctor. And if the doctor says it's okay, then, cool. But it's you really want to trust that is okay, and I'm not trying to throw any shade on doctors. I'm just saying, from a human standpoint, we all couldn't work, we couldn't do a lot last year. And so if they were stuck and, they couldn't make, they had payments to make, you're damn right I'm going to tell everyone telehealth will work, even if I know it won't,
Right. Yeah, and I can see that point. Yeah.
So I think it's a tough situation.
Yeah, and I think we've seen up north, at least, a lot of doctors are doing the evaluations. We haven't been running into this issue like we were 6-8 months ago. I would say that out of a panel, once the strikes occur and we're left with one, it seems like 8 out of 10 are scheduling in person. Hasn't been much of an issue.
I think that the rub is going to be a case like this comes out, and now applicants are going to say, I don't want to go. Even if the doctor's willing to meet, the applicants are going to say, I don't want to go. I'm a branch Covidian and I'm afraid of dying. And so, what are you going to do then? Right? Because the doctor says, oh yeah, well, I could see them telehealth. Applicant says, I don't want to go. And then you're in a situation like the applicant's choosing
right
the telehealth. It's not the doctor. That becomes a weird fight we have to consider.
Yeah. No, absolutely.
So this case that just came down the wire, the applied materials case, it's entirely too complex as far as a fact pattern goes for us to get into really any details on it. I think we can give you a drunk history version of it, where we essentially think we're just talking about a typical industrial injury with multiple dates of injury. Applicant goes and seeks treatment. Case settles via stipulation. The parties agree to use Dr. Massey as their primary treating physician. The applicant continues to treat with this doctor until such time, allegedly, the doctor abused his relationship with his patient and started having sexual relations with her. The applicant alleges that he held her benefits and treatment and medications as hostage to having this sexual relationship. I don't know what happened. I don't think any of us know truly what happened, but those are the allegations that were made. The applicant saw a psych PQME who found that the applicant was suffering from PTSD as a result of the treatment from uh, Dr. Massey and the subsequent affair, um, and essentially said that the applicant was 100% permanently disabled based on her psychiatric condition and her inability to work, but gave her a GAF score of 45. Um, so, following that trial, the judge awarded the applicant 100% disability, and it went up to the Sixth District Court of Appeals, and that court addressed, the various issues involved in this case. First, and possibly most troubling, but I don't think that this particular fact pattern we're going to see often. But even something as intentional as a doctor committing malpractice by pursuing a sexual relationship with his patient um, was found to be a compensable consequence to her treatment. That is a troubling expansion of what a compensable consequence can be. And, like many of the other cases we discussed, is probably going to be fact specific because, like I said, I don't think we should see this often.
Yeah, and
But
I think
you,
when I was looking
you
at
never
it,
know.
I think there was a few things that if they were different, we might have seen a different outcome, at least on the compensable consequence. So, and like where I mentioned, this I think was a 70-something page decision, so we could do it just an hour talking about this. But like as far as the condensed version, so she alleges that the sexual contact and inappropriateness started at his office during appointments. So I think that's one piece of it, that he was
Mm-hmm.
groping her during appointments. Then it sounds like it went to somewhat of a consensual sexual encounter for a month. Then he continued to go to her home where she was rejecting him and declining the sexual advances. Then shortly after files the complaint. So the appellate court in this seemed to really latch on to the theory that consequences of medical treatment are going to be compensable, and that it
Mm-hmm.
started at the office. And the defense was arguing that this was a consensual sexual encounter that was outside of the purview of industrial medical treatment, didn't arise from employment, that kind of thing. Um, and I think if it was simply that they started dating and it had an inappropriate relationship and it moved outside, I think it might have been a little different. But there were
Yeah.
some specific facts that the appellate court put forth that made it sound pretty inappropriate from the start. Like you mentioned, that the doctor was allegedly threatening to cut off her disability slips if she wouldn't see him, if she wouldn't let him over, those kind of things. So,
Yeah.
like you said, it's a spat. It's a disturbing, uh, probably fact specific situation, uh, but it would generally seem that it ex- expands what could possibly be a compensable consequence
Yeah.
injury
Absolutely.
per se,
Right.
um, because it's a very twisted situation that's going on there.
Yeah.
And
And then the upholding of the Fitzpatrick, if you want to touch on that.
so the Fitzpatrick case obviously was a big case a year or two ago, which discussed 4662 and how you can rebut the strict schedule and get to 100%. And in that case, the Fitzpatrick case, you had an AME that essentially said, okay, this person is 100 based on the facts. In Fitzpatrick, the court said, well, no, you can't do that. You can only go through established ways. You can go through rebutting the schedule via Ogilvy, uh, LaBeouf, and the Dahl line of cases as to whether somebody is amenable to voc rehab, or you rebut it in the four corners of the guide through Guzman. Those were the two ways that Fitzpatrick said you could do it. So this case was very similar to Fitzpatrick in the sense that you had the AME psych saying, well, this person is a 45 GAF, which I believe translates to 40 or so percent whole person rated out. But on a psychiatric basis, she can't work, is what he says, what the AMA says. And the judge in this case essentially does exactly what Fitzpatrick did and awards 100% based on the AME report. So I think the good part for defendants that came out in this is that the court upholds Fitzpatrick because the applicant was trying to say that Fitzpatrick was wrongly decided. So the court upholds Fitzpatrick and says, no, you can't do that. The court also says that even if you went through rebutting on the LaBeouf side of cases, through Ogilvy, through Dahl, trying to say that the person is not amenable to rehab, that the AME in this case is not a vocational expert, and that it wouldn't be substantial evidence, even if the AME said that they were not amenable, which is sort of the first time that's happened. Because, when you're looking at rebutting it, or an applicant rebutting the schedule, many times they will ask the AMEs and QMEs if they can go back to work or if they're amenable to rehab. And this case seems to add a little bit of ammo to defendants where you can say, no, an AME, QME discussing those kind of work restrictions, if they do just throw out this 100% scenario, even if they use the right words, according to the Dahl and the LaBeouf line of cases, even if they use the right words, it probably would not be substantial medical evidence because they're not a vocational expert.
Right.
So those were the big things I took out of it, the evidentiary part, and then
Yeah.
that Fitzpatrick is still good law.
Yeah. And I feel like that's a good learning moment for both sides when it comes to AMEs or your PQMEs, like addressing just disability and voc rehab issues or ability to work issues.
Yep.
Is they're not qualified to do it. So if you need to rebut the applicant's voc rehab expert, you need a voc rehab expert. You can't rely on your medical doctor's opinion. And then if the doctor is saying 100% and they don't get a VR expert, maybe you just sit on your hands and let them,
but I think
hang themselves by there.
For defendants, I think, like you said, that's a good point because, we see so many of these god awful, ridiculous vocational reports that are clearly absurd on their face that an applicant attorney will just go get. And it says they're 100 and they've got 20% permanent disability under the guides, but yet they can't work. And what you want to do as a defendant is just to ram it to the WCAB and show that this voc report is clearly not substantial, like you said, but your QME report is likely not going to help you when it comes to the vocational issues. So you have to go all out in those cases. Make sure you have a rebuttal report pointing out all the flaws in these templated vocational applicant reports that we see, and providing lists of the jobs the applicant can do within their restrictions so that you don't go down the path of getting blindsided.
Right.
Because that's what would happen, I think.
Yeah. So, I mean, that kind of wraps up the cases that we had prepared for discussion today. We'll be putting in the notes, the case sites, and I'm hoping to be able to do chapter markers so that you could just kind of skip around and listen to the discussions that you're more interested in. But if you have any questions about any of these cases, you can reach out to us at any time. Thanks, Jason, for jumping on.
Yep. Nice to see you, Roy.
Good to see you, buddy.